Good afternoon and welcome to this book launch seminar. My name is Anna Wallerman-Gavanini and I will be the chair of this event, which is organized by the Amsterdam Center for European Law and Governance. And first of all, I should advise everybody that we are recording this event. So the purpose of this seminar is to discuss and to celebrate the new book by Professor Päivi Leino-Sandberg, The Politics of Legal Expertise in EU Policymaking, which is very recently out from the Cambridge University Press. And this is a book that takes us into the corridors of Brussels powers and into the legal services of the EU institutions, which are practically a very important player in the Union, but one that we know very little about. So this book really fills a gap in the state of academic knowledge. And I must say that one of the things that I particularly enjoy about it is how it connects this topic of legal services, which, as Päivi herself writes in the introduction, can seem very dry and technical, but she managed to connect it to fundamental issues of the integrity of the law and the legal legislative decision-making process, which in a way that I find really fascinating. But I shall leave commenting on the book to the excellent panel that we are really pleased to have this afternoon alongside Professor Leino-Sandberg. So I will just give a brief introduction. First, of course, we have the author herself. Päivi Leino-Sandberg is Professor of Transnational European Law at University of Helsinki. She's a Deputy Director of the Erik Casten Institute for International Law and Human Rights, and she currently acts as leader for no less than 5 international research projects. Her main research interests relate to EU decision-making, democratic governance, and the use of legal and other expertise, which of course is all topics that we will be discussing in depth this afternoon. And as evidenced again by the topic of today's seminar, she publishes regularly in leading academic outlets, and she also engages in multidisciplinary work. And we should also highlight, I will not go through her entire CV, but that she has worked for 10 years as a legal advisor for the Finnish government, which of course is an experience that has been significant for the work that we are here to discuss. Besides Päivi, we have 4 commentators on the panel. First is Professor Christina Eckes, who is a professor of European law at the University of Amsterdam and the director of the Amsterdam Center for European Law and Governance. Her current research interests are the legal limits to European integration, the separation of powers and sovereignty in the 21st century Europe, and she currently is the leader of a Norface funded project that inquires specifically into the separation of powers in modern day EU. We have Professor Elise Muir, who is head of the Department for International and European Law, head of the Institute of European Law, both at the University of Leuven, and also a visiting professor at the College of Europe. And she is the principal investigator of Reshuffle, which is an ERC starting grant project that reflects on the constitutional implications of the increasingly powerful role played by the European Union in the field of fundamental rights. We have Professor Harm Sheppel, who is a professor of economic law and a director of the law program at the Brussels School of International Studies at the University of Kent. And his research concerns in particular the legal institutionalization of capitalism on different levels of governance, drawing on institutional economic, political economy, and economic and legal sociology and theory. And last but certainly not least, we have Professor Jonathan Zeitlin, who is a distinguished faculty professor of public policy and governance at the University of Amsterdam and an academic director of the Amsterdam Center for European Studies, and whose current research focuses on new forms of experimentalist governance within and beyond the European Union. So we have 4 highly qualified commentators here today. And we're going to do this in the way that I will first give the floor to the 4 commentators. Then Päivi will have a chance to respond to their comments. And then we will open up the floor for questions and comments from the audience. So I give the virtual floor to Professor Christina Eckes.
Thank you, Anna. You didn't say that the project SepaRope on separation of powers is actually a co-production between Päivi, Anna, and me. So that is certainly a joint interest on which I will also push Päivi further in light of the book that we are discussing today. But let me start by congratulating Päivi for this book, because I really think it makes a great contribution, a great descriptive contribution above all, on something that is really hidden from the view. I mean, most of us have studied EU law for a long time, but we haven't engaged with this. So how do legal advisors in the different institutions work? What are their tasks? What is their influence? What is their role? And it does so also in a quite critical perspective. I mean, you emphasize, Päivi, at several points that the greatest contribution is a descriptive one, and that is probably true. But I mean, you clearly also analyze it in a very critical manner at many points. And what I was most fascinated by is how elegantly you weave in all these interviews. It's so much interview data that you present in a way that is really a great read. And I think the other point that one can feel throughout in this balance between the internal and the external perspective is that you had the 2 hats, as Anna already mentioned, so that you have a certain insider perspective, while at the same time you offer external reflections on it. And I want to push you a bit on the second, namely the external reflections on it, and invite you maybe to reflect with us on some of these points and the implications that the findings of your book have in the context of our SepaRope research project, so with regard to separation of powers, but also elsewhere. So I take from the book, and also from your recent article on Next Generation EU, but also on the article we wrote together on the Modern Law Review article we wrote together on the EU-UK Trade and Cooperation Agreement, that you are deep down a formalist. And I don't mean that negatively, because I would call myself a moderate formalist. So I really think this is rather that it shows that, to me, it shows to an extent why we met in a research project called Separation of Powers in 21st Century Europe, because that, of course, implies a certain commitment to formalism. But that's what I would like to push you on, namely this juxtaposition that you make at different points in your book between law and politics. And that is, of course, something that is politics. I think as you use it, you mean day-to-day political struggles. So you don't mean to imply that law is not political or anything. But so just to make sure that this is not misunderstood. But of course, in the context of your book, it's even a step more difficult maybe than in this context of our research project, because you don't have the different institutions. So you don't have an institution in charge of the law, hence the court, and the institutions that draw their legitimacy from other sources than just legal sources. So I think in the context of the advisors, I would like to ask you now specifically to develop on the tensions that you highlight in your book. And I think that are true tensions, and that is the loyalty of the legal advisors to their own institution, which you work out and you say, you know, their institution, and you do it in your book with regard to the Council, the Commission, and the European Parliament. So their loyalty to their client, if you like. And so the first loyalty. The second loyalty, the loyalty by the legal advisors to the integrity of the law. And that is also how you call it. So a very Dworkinian concept of coherence, but also drawing justice from this integrity of the law. And so the second loyalty, and the third loyalty to the public. So I don't think you use the word public. I think maybe you use citizens but I mean by public, the broader, EU citizens, the broader public. And in that tension, so I would like you to develop how these three loyalties, how you see them and how they stand in tension with each other, or at least I see them standing in tension and how that comes out. And link it to the question, can legal opinion ever be purely legal? Because you don't, I mean, I remembered you using the word purely legal, but I couldn't find it because unfortunately the PDF doesn't do control search, that is blocked. And then I couldn't find it any longer, but I did find a sentence that I want to cite to support that. That is something that comes regularly up, I think, implicitly in your argument. You say on page 305, sticking to legal questions while staying clear of political ones. And that is in principle what I would like to push you on. Namely, or at some point you say giving objective advice. So this is of course a clear commitment to a very formalist perspective in my view. And I'm wondering, where are the extra legal factors? Where do they come in? I mean, we have so much scholarship showing that the law cannot be seen in isolation. So where are the necessary value choices? And how is it at all even thinkable to stick to the legal questions and not to the political ones, even if we understand political as day-to-day political struggle, rather than let's say what Duncan Kennedy would think of as ideology. I don't necessarily mean that so much. And then also to develop a bit more on that question that comes up in formulations then that links to the second loyalty, no, sorry, to the third loyalty, namely the loyalty to the public. You basically ask in whose name are they acting? And that comes up in questions where you say, so whose advice? That's fairly, maybe in chapter 2 of the book, where you discuss so in whose name they're giving advice, but also when you come up with the client's wish list at the end, there's so this tension. And in that sense, I would like you to consider, does law necessarily represent the public interest? Or is that at least an implication that to a degree I take from it? So that's my first question. And then, yeah, maybe that takes us a bit back maybe to, I mean, I'm going to skip this. I mean, this would take us even back more to separation of powers, and maybe I get that into the discussion. I have a few more questions, but I also want to stick to my time. And the next question I want to ask you is links particularly to chapter 4 on confidentiality. So you dedicate a chapter to each of the institutions and how the legal advisors work within the Commission, the Council, and the European Parliament, and you have a chapter on confidentiality of the legal opinion of the legal advisors. And there, what comes out is, above all, also how much this is a power struggle, whether a legal opinion is made public or not. And in that context, I would like to ask you, how would systematic disclosure, in your view, change the relevance of law/legal arguments in the discourse? And that is different, but related, I think, to the questions of how would that change the power of the legal service, because that is something you do discuss. You discuss that sometimes opinions are leaked for strategic reasons, and that you also discuss that, of course, as a confidential opinion can be more easily ignored than a public opinion. So you do discuss the power of the legal service, but I would like to ask you, what would that mean in you? What could that mean for the relevance of law in the discussion, and by extension, maybe to the power of the court in this? And then also related to that, I would like to ask you to reflect on whether that has changed, because what I found interesting is some of the people you interviewed in your book, or those who are named by name, some are mentioned by name. I have also had a similar discussion on the relevance of law from the perspective of the legal service of the Commission in the discussion. And some of them have suggested to me that that relevance of law has actually diminished over time. And I would like to press you a bit whether that relates to your understanding of the situation. So whether you think that the relevance of the legal argument in the decision-making of the institutions has been reduced over time, or whether you think that is difficult to say because your book covers only a limited, let's say your book is a perspective largely from the current situation. These are my questions, Anna. I give the word back to you.
Excellent. Thank you, Christina, and very good timekeeping. Päivi, I hope that you are taking notes, and then I will go directly to the next commentator, which is Professor Elise Muir. So please.
Thank you very much, Anna. Thank you very much to the ACELG for this invitation, and I was very pleased to accept warm congratulations to Päivi for this extraordinary piece of work. I'm not sure if every member of the audience has read the book. I gather that the organizers have decided not to summarize it, so I won't. But if I may just make a couple of general comments in terms of who I think could be interested in the book before asking a few follow-up questions. To me, it's a book of very advanced EU institutional law. I think it's a must read for any EU advanced institutional constitutional lawyer, perhaps even for institutional lawyers in general, even outside of the EU bubble. I think it's for the methodological reasons that I will introduce in a few minutes. So why do I think it's useful for EU lawyers in particular? Well, I think it informs our understanding of the machinery of EU law and EU decision-making, EU enforcement, EU litigation, because Päivi looks at all the type of tasks that the legal services contribute to, and these are not just lawmaking. And it's also very useful to illustrate dilemmas on the multiplicity of technical areas of EU law. And I'm thinking here, for example, I will use your text, Päivi, to illustrate, and I have a long list, but for example, all the dilemmas on the choice of legal basis, where there are rules, formal rules on how to choose an appropriate legal basis, but you show, it's not the first time you wrote on this before, but here you show again very well how the choice of legal basis is the subject matter of intense discussion between institutions and legal services. The same, what is the political commission? What are the implications internally? What is the role of the presidency in negotiating a legislative file in relation to the legal service of the council? I thought was really interesting. The implications of transparency and access to documents, very, very specifically discussed, as Christina pointed out. The dynamics on infringement actions were also very interesting. How does the commission decide or not to push for certain infringement actions? The role of the legal service of the parliament in contrast or in relation to the UDI committee was, I thought, also very interesting and perhaps little known by us external observers. So clearly many very interesting points. To me, the most interesting and the one I will for sure again use is your analysis of the role of the council legal service, which we know as being a powerful legal service. But here you also explain and put forward some explanations. This is a legal service that operates in an institutional setting where there is less strong political guidance from the top. So the council legal service basically is the one to offer solutions for political compromises, even more than in other institutions. So for all these reasons, I think it's an advanced book on EU institutional law. I think it's also extremely interesting methodologically, and I want to thank you. I cannot thank you more than I will now for doing this. I mean, I'm so glad that a lawyer engages with a legal narrative on an empirical analysis. I mean, too often I think we let this law in context approach to non-lawyers, so then it doesn't necessarily remain law. So we have a lot of empirical studies or political science or historians or philosophers engaging with these with our legal machinery, sometimes in very useful ways, other times I find less useful ways because then I don't understand as a lawyer what I can get from it. But here I think you're doing a wonderful job of informing at least my understanding of EU law with your interviews, which are not just the interviews, but are combined with thick doctrinal analysis, legal research on internal organization of institutions, literature on the role of their various actors in lawmaking, and so on and so forth. So I really thought that was this very powerful element of your work, and I trust it will be useful actually to political scientists, perhaps to historians. Your work made me think a bit of that of Luc van Middelaar, who just presented also recently his new book. He's a historian, a philosopher, but he contributes to our understanding of the law as a non-lawyer, and I think you can contribute to the understanding of the politics of EU law as a lawyer. So to me, this is a dialogue between various disciplines, which I really enjoyed. And I'm, again, hugely grateful that a lawyer engages into this. I enjoyed your style. I think Christina also said that. To me, it's a witty, sharp, and also bold at times. And so I like this. And this is also a book which is in the feminine throughout, right? So all key players are he or she or her opinions, which I thought was also good and refreshing. So this is a bit for my overall promotion of your book, Päivi, a must read. And I think that one of the key lessons I take from your book is that the law, and here I will come back right away to the points made by Christina before me, to the law as a necessary common language in European Union affairs. So the law as a tool. To me, that's what your book is all about. It shows how law is a necessary language for the key players in European Union affairs. Why? Because the EU is, and you say this in your introduction, is a supranational structure. So, there are linguistic and cultural differences, and the language of the law tries to rationalize and give objectivity to a process, because it's a process that is in construction, under construction. And at the council, again, to come back to council legal service, I imagine that the law is the last resource to try and find compromises, really. So to me, your book is about the law, yes, as a common language, but also therefore as inevitably tainted with political compromises, right? That's what it is, and that's what your book shows. And so with this in mind, I was also a bit curious. I mean, I think if you assert, as you do, I think that the law is a subject matter of so many compromises and is inevitably political, then it becomes a bit difficult to claim that the law has an authority above everything else. No, that there is a sort of a dilemma here. How do you reconcile this? And I think it was my impression that it was also what Christina was pointing out in her questions. Like, how do you reconcile this claim that the law is inevitably the outcome of political compromises, and then in the same time, a legal service could claim to placing the law above other types of authorities? And so I was, on a couple of occasions in your book, I was wondering what was your ultimate stand? For example, you discuss at one point the Juncker Commission, so this political commission, and there is also this drama, the Selmayr drama. But more generally, what is your view on the fact that the Commission may want to be political and to have, as the College of Commissioners, having the last word on major legal opinions? Is that something that you object to, that is against your model, or is it not? And similarly, the other way around, perhaps in your epilogue, when you comment on Next Generation EU, and I'm familiar with your position on this, which I respect also a lot. I think you're critical about about the role of legal experts in this context. You refer to the now famous expression of these NGEU being legal high-tech by Costamagna and Goldman. And I wonder, in this context, this high-tech, so placing legal expertise above politics is what you seem to be taking issue with. But I wonder, can we narrow down the discussion to this? I mean, is that not underestimating the importance of the ultimate final institutions who signed up for this? And is there not a danger at undermining, at underestimating precisely the political responsibilities of the ultimate decision makers? And I mean, in relation to both examples, I don't think, to be honest, there is a perfect answer. I just think that once we accept, as we must, that the law is partly a combination of political compromises, and then it makes it really difficult to place, to draw the line between when the law becomes the last guardian or when politics become the last guardian. It's a sort of a virtuous or vicious circle, as you want to look at it. And I had a couple of other comments in the few minutes that are left to me, which relate to your angle of analysis. I think that your work can be described as an internal endemic analysis of how legal expertise works in the EU machinery, and that comes from your expertise and your experience. It's also what you did with all these interviews. And I think that's the great strengths of your work. Now, I have a few questions that push you outside of that zone, if you want to pick them up. So, for example, placing ourselves above these legal services, I wonder to what extent your work or some parts of your work or your conclusions call into question the idea of institutional balance, interinstitutional balance. Do these services, do the collaboration between them occasionally, does that call into question some of the constitutional principles on which the EU is funded? Another question I had related to your case studies. I completely understand Commission, Council, Parliament. You know, I'd love to see your next book on legal expertise at the Court of Justice. I mean, I'd love, could you do that? I mean, please. So did you think about this? How does the use of legal expertise within the Court of Justice work? That's a question that came to mind when reading your work. But there are others, so the European Central Bank, agencies, but that's unfair. Huh? I'm not saying you should have done all this. I acknowledge that you can't, but I'm just curious to know if you already have thoughts on what could be worth investigating with these other actors. I also have a sort of a more deeper question, like if I accept the narrow well, not narrow, but the confines of your existing studies, I wonder if there is not a sociological investigation to be done. So you explore this a bit at the beginning of your book. Who are these experts? But I wonder if this could go further, maybe with a sociologist, you know, who are they really? Like what type of social environment do they come from? How do they relate to the lawyers from their home state? I would find that extremely interesting as well. And a very last question, I wonder if you have any thoughts on external legal expertise. And I'm thinking in particular here on the role of blogs. Like academics in recent years blog a lot and react, you know, within a few hours of a judgment by the Polish Constitutional Court, you have opinions on how the problem should be addressed. And I wonder if in your work you looked at all at, how that fast legal expertise operates and interacts with the work of the long-standing experts in the legal services. And for example, at the European Parliament, I know that it's very disturbing because the legal service of the European Parliament receives phone calls based on these external opinions that people have been reading in a blog and that may or not be very well constructed. So these are as many questions, but I will keep to my 15 minutes and I look forward to the discussion.
Thank you very much. This will indeed be a rich discussion for Päivi to pick up later, but I will press on and give the virtual floor to Professor Harm-Scheppel.
Thank you, Anna, and thank you, Päivi, for the book, which was, Christina had promised me a good read, and a good read it was. I need to apologize in advance because in the building next door to mine, someone is drilling with enormous power. So if that starts happening, you may not hear me. So I don't know, we'll see. Okay, so it's more or less pushing on from the theme, which is the book is clearly well informed and written by a lawyer loyal to the law and also loyal to her sources. That is, if we're looking for gossip, you will not find it, at least not if it is not in public sources. So if there is not a newspaper article to back it up, then Päivi will not mention it, which is of course odd. Well, it's not odd. It is because she knows that we know that she knows a lot of things that she's not writing down, and that must have produced dilemmas for her. But by and large, I think she was right to do it this way. Now, it is, as Elisa says, advanced institutional law, and we learn a lot, which you probably would not from reading textbooks about the actual workings of the process. And so it is unfair what we're doing and what I'm going to do, which is to lament the fact that there is not enough sociology in it, because the choices made methodologically and otherwise are the choices that she made, and the book is a result of that. And discussions of books tend to be about what is not in the book, and that is unfair. And having said that, that is exactly what I'm going to do. So one of the things that I wonder about in the very concept of a legal service and producing legal opinions, and especially in one as structured and hierarchical as the Commission Legal Service is, how does the production of legal knowledge relate to bureaucratic processes? And so the Commission Legal Service is, it points out, fairly flat, which is true. It is also true that everything that goes outside of the legal service needs to be signed off. And especially formal opinions need to be signed off by a whole bunch of people. And so this hierarchical structure inevitably influences the way that legal knowledge is produced. And I wonder if Päivi could elaborate a bit on that. Then, of course, there's the issue of secrecy. That is, the Commission and all institutions leak as much as others, and so many of the things that are supposedly secret are in possession of Päivi and of me and of all sorts of other people, but still they are secretive. And so on the one hand, legal knowledge is produced by, the better legal reasoning, that is, legal truth is produced by the better legal reasoning. And on the other hand, there are structures within the bureaucracy that are almost veering towards the contrary of that, of openness, of competition, of battles of ideas, and how they are fought out. Which leads me to another fundamental question, which is, what do these people do? Is it, are they writing and thinking in a context of justification? That is, are they writing towards a preordained objective? Or are they generally writing in a context of discovery? Are they generally trying to figure out the best legal solution to a particular problem is? And my suspicion is it's much more the first than the second. And then sociologically, especially the Commission Legal Service is, of course, well, not of course, but it is a bit of a cult. It is a bunch of people with an innate collective sense of self-superiority, at least they used to have that. And they consider themselves the true guardians of the European project, and are quite upfront about that. That is, if they really have to leave their own office to go join a meeting at the services, they're standing. If they really have to, they will, but still not voluntarily. And I think that part of the story Päivi tells about the Juncker Commission and the threat posed to the Commission Service general, that is breaking down collective force.
Excuse me.
In exalting their own expertise and considering themselves the, yeah.
I'm sorry, but you are breaking up a little bit, I believe, or is it just me? So would you mind maybe going back a minute or a little bit in your argument?
God, did I freeze?
Yes.
Oh God, at what point is there's no way I can read.
Round about the Commission Legal Service being a cult.
Right. Okay, so I wonder, under Juncker and Selmayr and the threats posed to the legal service by putting it under the Secretary General and carving it up and making it much less powerful than it now is, I wonder if Päivi has an explanation for that other than the political commission trying to push through or being less burdened with the legal service as it was, because there is something about that collective, as a social group, the legal service, I think there's something in there which may or may not help in that. So another question is about the European Parliament's legal service, because this is fairly complex. Now, Päivi plays it down a bit, the power of it, and says, well, in the Parliament, the legal service kind of hangs around for people to ask them questions, and most people in the Juri committee or other committees would actually prefer not to ask them questions, which is true. It's also true that the Parliament Legal Service has developed a line of thinking, which is that their job is to maintain the institutional prerogatives of the Parliament. And they will not be drawn into any way. So, for example, if requests are made to the legal service to go to Luxembourg for this or that, then the legal service will say, well, no, only if it is about the institutional prerogatives of the Parliament. And so we're not going to help you with political questions. And that brings me back to a theme in the book, which is it really helpful to make a distinction between law and politics the way you do it, in the sense that the stance of the legal services by exalting the purity of the law is, of course, in itself a deeply political exercise. And I wonder, especially in the project of European integration. So I wonder if Päivi could put a few words on that. That is, that's one thing to say, well, there's law and there's politics. It's quite another thing to say, well, the privileging of a particular type of reasoning is in itself, of course, a deeply political commitment, and one that cannot be discarded that easily. I'm sorry if most of what I said was frozen in time or in space, but those are my reflections. So thank you very much, and thank you for the good read.
Thank you very much. And no, not at all. It was only a very short moment when there was a bit of a hiccup, and we were mercifully saved from your drilling neighbor as well. So thank you so much, and I will give the word now to Jonathan Seitlin.
Thank you, Anna. And of course, it's a challenge after these three very penetrating and insightful comments to come last, but I can also build on some of the things they said. I want to basically take up a number of themes. First, like everybody else, I want to praise the book and say what I found interesting and valuable about it. Secondly, I want to say something about its methodology and the use of interviews, but also of documents. Thirdly, I want to say something about the relationship between the descriptive and the normative aspects of the book. And finally, I want to address the normative aspects themselves, because I think it is actually I mean, Christina called it a very critical book, and it is that, but it is also a very strongly normatively charged book. So just to say some of the things that I appreciate, I mean, to go into the topic itself in the depth that you do is already a major contribution. I mean, I thought I knew a lot about the EU and how it works, but I have barely come across particularly the Council and the Parliament's legal service, the Commission legal service. I was familiar with, but not in any kind of depth. And so I find that to be already a major contribution. The most interesting parts of the book for me are about the interactions between these three services and the light they shed on, indeed, the interactions between the three institutions that they represent in the making of European law and policy. And I agree that the institution that comes to life most in the most revealing way is the role of the Council legal service. And I think that's really an important contribution. I know that you cite one or two articles that have already been written, which I had not read, but still, I think that's quite important. And I also found particularly interesting the discussion of recent controversial developments, the political commission, the efforts to change the role of the legal service within the working of the commission that Harm has just mentioned, the discussion of next generation EU, but also the discussion, for example, of the debate about the flexibility communication on the Stability and Growth Pact, where it seems as if it may be that the Commission Legal Service itself leaked its opinion because it was overruled. At least that is a possible interpretation of the story that you tell in the book. I mean, secondly, I find interesting something that people have already talked about, and that is the reflection on the different possible roles of the legal services or the people who work within them. And you cite a piece, I think it's about international legal advisors, which is called something like consigliere or conscience. And I think that largely you situate your discussion within that framework. And I would say you broadly come out to say that it's understandable that legal advisors should be expected to serve as consigliere, and especially, let's say, in the Parliament and in the Council, but it would be better if they also acted as conscience. I think what I did find a bit missing was exactly the third C, and which is that Harm mentioned, that is as cult, as self, going beyond a conscience to be a kind of self-appointed guardian and interpreter of the law. I sometimes, when I interact with the EU lawyers, I sometimes talk about the religion of law in the EU, and clearly the legal advisors, and probably especially in the Commission, are or see themselves as the priests of that religion. And I think you could have said more about that dimension. I'll come back to that in a minute. I mean, let me just say also that you're probably not aware that there is a novel about legal advisors in the EU, which is even a detective thriller that Christina has got you a copy of, and will send it to you, called Les Compromis. It's in French. And the hero or the villain of the story is, I'm not sure that such a person, such a character really exists, is a seconded national advisor to the legal service of the parliament. I don't know if there are any such, from Denmark. And he very much is somebody who sees himself as a guardian of the law and of the treaties against the usurpatory and villainous actions of parliamentarians who want to go beyond the legal basis, in this case, for a new diesel regulation, a new regulation regulating diesel engines after Dieselgate, and I will come back to that. But he would be a kind of caricature of this third figure. Okay. Secondly, on the methodology, I mean, also as a social scientist who does empirical research, I very much appreciate all the interviews that you did, and still more, in a sense, the valiant efforts that you make and sometimes succeeded in extracting documents, because there is a kind of problem with the interviews. And this is something that everybody who faces confidentiality is aware of, that many of the interviews basically, they talk in generalities. How do things work and how do people think about themselves? And I always ask the question, maybe it's because I was trained as a historian, okay, but you know, give me an example. How does it really work? How did it really matter? And there you're most able to do this when you actually have a leaked document, or a document that you've obtained through your freedom of information requests. And so that is a kind of frustration. So I think actually in many respects, particularly the council, that's one of the reasons why the council legal service comes into more illumination, and to a lesser extent, the parliament, because you are able to use these documents to get down to specific cases. Thirdly, and that brings me to my third theme, which is the descriptive and the normative. And as I said, I do think it is a very strongly normative book that you have or express views about what should be the role of the legal advisors. And also, I mean, here it comes back to the kinds of questions that Christina asked, that you express views, particularly in the epilogue, but all the way through the book, about the extent to which the EU seems to be exceeding the limits of a reasonable interpretation of the treaties, particularly viewed from the perspective of certain Nordic countries who have a rather contractual view of conferral of powers and competences. Now, the comment I want to make about the descriptive side, I mean, in a moment I'll take issue a little bit on the normative position itself, but I think it actually it leads to a kind of blind spot in the book. So at some point in the book, you say, sometimes policy officials, you're talking about the Commission Legal Service, feel the legal service is overly conservative and reactive rather than creative. This could lead to cases being blocked or stalled for a number of years, causing dissatisfaction in the DG. But you don't investigate that at all. And I think that would be a very interesting question. For example, I wonder if she is still here. Yes, she is. So Maria Weimer is here, and in her book on GMOs, she emphasizes the problems created for the EU by an overly legalistic interpretation of Article 114 of the treaty, which, at least as the Commission has interpreted it, does not allow it to go beyond the relatively narrow scientific risk assessments done by the European Food Safety Authority, and to take into account other legitimate socioeconomic and cultural concerns that member states may have. And I wonder whether behind the scenes, the Commission Legal Service isn't part of the problem here. And whether that whole issue of sometimes the Commission or being too rigidly legalistic is not a barrier to sensible decision making. And finally, the normative issues. I mean, there it's. I mean, I guess I would personally feel much more sympathy with the, let's say, the flexibility communication of the Commission, the next generation EU, prioritizing infringement proceedings to the ones that are most important. And I wonder if they didn't already do that informally in the past. And I guess I find it, hard to imagine that you could really run an institution like the European Union on the basis of a strict interpretation of conferral of powers and competences, and especially in a world where the effective constitution is the treaties, and the treaties are increasingly difficult to amend. It's not surprising for me as a non-lawyer that people find it possible to reinterpret creatively not only law but the primary law itself in order to solve problems that need to be solved. And the alternative seems to me a little bit like fiat justitia pereat mundum, which I think is neither really an attractive nor a persuasive political credo. And I will finally say, even at the risk of giving away the plot of the novel, that this Danish seconded advisor murders two parliamentarians because he feels that they have overstepped the boundaries of Article 114 and are part of a tendency to transform the EU into what he calls a golem, a creature that has become independent of the member states that created it originally. And your position is much more nuanced and sophisticated, but I wonder whether you wouldn't have a little bit of sympathy for his views when you read them. I'll stop there.
Thank you so much, Jonathan, for those vivid images, and for your very insightful comments, of course. And thank you to our four panelists for really delving into this topic and for keeping on time. It's not so often that you ask 4 professors to speak for up to 15 minutes and you're actually done an hour later. So thank you so much for that. I will now give the floor to Päivi for answers and comments.
Ooh. Well, let me just say, first of all, thank you so much for all these very sort of rich comments, and also very kind comments, because obviously this is now the first book launch. So this also gives me a good opportunity to practice my arguments among friends, which is very, very much appreciated. Now, I'm not sure if I should start going through them one by one, but I think there are some themes that came up several times, and at least those I would very much want to discuss. And there's actually one comment that I was fearing I would get, but which didn't come up. And for that, I'm thankful, because obviously what in a way I'm most worried about is that the book would be read as sort of very harsh criticism of the legal advisors, or that people would read it as me thinking that they're bad people, you know, that they're doing a bad service to the European Union. And actually, I think completely the contrary. I think they're doing a lot of work. I mean, I don't see anything sinister or bad in what they do, but I do want to sort of, in a way, make it more visible. And also, I'm interested in the structures and the assumptions that guide their work, because I think they're very relevant for how the EU develops. Now, what should I start with? Maybe the question of relationship between law and politics and formalism and procedures, because that came up several times, and I think it's in a way, I mean, it's of course the core question of the whole book, and the whole question of what we mean by law's integrity and whether there is anything known as objective legal advice. And obviously, I mean, I don't think there is. And when sort of trying to frame the book, that was actually the point that I started with, and I actually spent several days discussing things with Panu Minkinen, whom we had the chance to hear last week. And I said, what can I say about it? Because I don't believe that there's ever such a thing as objective legal advice. However, then I started thinking about the method, and obviously that setting needs to flow from the interview data that I have. And there, the understanding among the people that I study is very strongly that they need to preserve law's integrity. And that doesn't only refer to sort of coherence as in other literature, but specifically to the point that law should not be polluted and they should not be guided by national wishes. In particular, that's the thing. I mean, they should never be guided by their own member states, and also in the parliament specifically, not by political groups, in the commission, not by DGs, that they should in a way try to keep it as clear as possible. But obviously, in offering advice, they constantly make choices between different things. And some of these are maybe more technical, others are more political, but they're always political, and they're always operate in a political context. So in that sense, whatever advice they give will have political consequences, and choices need to be made. And in a way, what interests me is how that balancing is done. And of course, that also flows from the experience of having sat with these legal advisors in many meetings and having read their opinions. And of course, when you come from that frame, you often see that solutions that are promoted, for example, as the only possible solution really is not. I mean, there might be others, but you're not really looking in that direction. So in that sense, that would be my sort of thinking, that the idea of keeping it unpolluted flows from my object. Yet, I mean, when you keep on talking to them, of course, most of them will say, well, this is very difficult. You know, it's a difficult exercise, but you have to struggle. So in that sense, it's the core dilemma of their work, that's what they feel they have to defend, but it's a difficult game. And of course, then it also links to this question of being a formalist and believing in procedures. I mean, maybe for 20 years ago, I thought procedures are boring. You know, who cares about which procedure? And then as you grow older, as I have done, then you start understanding that actually procedures exist to protect many good things, that procedures are there to make sure, for example, that the right people have been heard, and that effects have been evaluated, and that those who are affected by decisions should get a say. And also certain procedures have strong guarantees for participation or transparency, which are also very, very relevant for the sort of final product to enjoy legitimacy and be accepted. So in that sense, procedures exist to promote something bigger. And in that sense, they are quite important. I don't actually think law should always override politics. I actually often think politics is more important than law. But I also think that in those cases where clearly, for example, treaty provisions are being reinterpreted, or will find flexibility where it did not exist before, it is important to have a good broad discussion about the significance of the change and what the new understanding means and what kind of consequences it will have in other contexts, because usually these implications will be broader, and we should also discuss them in an open manner. So maybe that, just to say that sort of in general about that theme. The Commission, that came up several times, the question of the Commission becoming political. I must say, when I started writing the book, obviously the legal service that I knew most about was the Council Legal Service, because that's the legal service I had been working with on a nearly daily basis for 10 years, and often we had difficulties with them. We disagreed with their interpretations, found them very political, and they're very sort of geared towards certain solutions, and also difficult to work with, simply because they have a lot of power in the council structure. But then somehow I thought, well, you know, maybe the council is really not that. Maybe it's the Commission that is the worst case. And I then worked quite a long time on the Commission, and ultimately actually found a lot of sympathy for the Commission lawyers, which I actually initially did not expect to find. But in a way, the faith in their mission and the idea that they are really keeping the union together, and in a way they're understanding that that's the job that they have with the Court of Justice. They see themselves very much as a team with the court. So there's a very close relationship between those institutions, which we might not necessarily see very clearly from the outside. So they think that they have a job to do in Europe. Is it a problem that the Commission becomes more political? I think yes and no. I mean, it is a good thing for certain purposes, but it brings with it other problems, such as the equality of member states, and it undermines faith in the Commission, in the Council, which might be something to take quite seriously as well. So it might promote certain objectives, but have difficult setbacks for other problems. And there, when you're thinking about the role of the legal service in particular, I think there is one element of that is the discussion of the Commission as an institution becoming more political. But when you have interviews with people working in the Commission, there's also other thinking, which seems to have long roots, which is that the legal service is too powerful, and that it limits the DIG's work too much. And there, Harm was asking about in a way, the conservative preordained function of legal services. I think that was particularly clear in the Commission. There was felt that the Commission is far too conservative, and it prevents the development of the union in a good direction. It's much too focused on the court, and there the relationship between these two institutions becomes quite vital, that it only thinks about what will happen next in the court and whether it will be able to defend the Commission in the best way, which prevents it from being proactive and promoting good solutions in Europe. Finally, maybe at least, well, there's the question of the interactions between the legal services that I've actually find very interesting. And the fact that I think what I understand from my interviews is that increasingly legal services are delegated tasks to sort out among themselves. It's actually something they tell me is on the increase, that, for example, in trialogue negotiations, bulks of the text are sent to the legal advisors to sort out. And of course, that is interesting when it happens in the trialogue context and quite relevant for democratic decision making as well. Then maybe just two more things about the methodology. No gossip, no leaks. Well, I must say, I had so many nightmares over the summer when I was going through the proofs for the final times and still thinking whether there is something that somebody can be identified with. That's always the risk when you're doing, and the difficulty when you're doing interviews, and I'm still hesitating whether to recommend it to anyone, because obviously it is so much work. It's so much work, and simply the bulk of data is so incredible. And then when you do interviews over a longer period of time, I've learned that you have to be very careful from the beginning with doing everything right and in according to the book, so that you've got everything recorded in accordance with ethical standards. I fortunately did this, I think, quite carefully from the beginning, but still it gave me nightmares towards the end, because obviously lawyers are a special species as well, and they know their rights. And I also know that many of these interviews I would not have got if on the presumption that people can be identified from them. So of course that then you think about direct ways of identification, but also identification based on what they've worked with or what they tell you. So I mean, it is sensitive, and I'm still sort of thinking that hopefully I've made no mistakes there. I've tried to be very careful, and I hope that no accidents have happened. Also, the issue of leaks, of course, that links with the question of confidentiality of legal advice, and that really is a difficult question, because I've needed to state as a part of my ethical obligations towards the funder that I'm not promoting leaks, and I'm not using anything that isn't officially in the public domain. That has led me to court once. So I have a court case that I've already won in the European Court of Justice. It's been pending for 3 years now. I'm still waiting for the final ruling from the General Court, and now actually trying to go to court for the second time just around this week on another issue, which also concerns something that actually I think one could get their hands on quite easily, but which hasn't been publicly disclosed. And of course, that is a bit of a problem for a researcher. When so much, especially of legal ed opinions, are out there and they're circulating, people with privileged access get their hands on them, but formal channels continue to be very difficult to use. And I think in a way that is something that speaks for broader disclosure of legal advice. But maybe I will stop there and take questions. And if you feel that I should have addressed something and I didn't, I'm happy to go back to it.
Thank you, Päivi. Then I think the floor is open. So if anyone raise a virtual hand or possibly a physical hand, I will try to note them. Maybe while the audience is gathering their thoughts, I might raise a question or two of my own. And the first one actually concerns the methodological part of this book, because I agree with what Christine and Jonathan said, that you say this is mainly a descriptive book, but I think it's much more. It has clear critical normative perspectives as well, and I think the book is better for it. But I wanted to ask you, how have you been thinking about working in parallel with this empirical data, which of course is descriptive? I mean, what you learn from interviews is something about the world as it is, so to speak, and then you juxtapose it with the legal documentation, the legal work, so the normative perspective. And this is something that I personally have found really challenging in my work. So I would really like to hear something about how you approached that problem, really, of working normatively and descriptively at the same time. And then perhaps I wanted to also pick up on Elise mentioned the sort of the feminist side of this, and maybe I will just briefly, because I think most people, as we noticed, haven't actually got the books. I will just briefly share your wonderful cover, which I think is I mean, it's marvelous. And what the question I wanted to ask, Elise mentioned this sort of the feminist side to this, and I think the cover speaks very clearly here. You know, this strong girl in pink defending the law, and of course, you also your use of pronouns. But I wanted to ask, could you elaborate something on the sort of, is there a feminist thought or a thread going through this work? And could you elaborate a little bit on that perspective?
Yes, please. Well, the internal, external, that's of course is also something I was thinking about very much when I started with the work, especially when I started writing it, because obviously my reason for getting interested in this topic is that I've been an internal participant and I've seen it. And I've also seen a lot of things there, which I think, as Elise was saying, people do not generally know too much about. And I felt this is something that should be shared, because there's so much law below the surface, which we really don't know when we focus so much, for example, on the court and its role in the interpretation of the EU law. And of course, I mean, my reason for wanting to write it is also that I think there's something wrong with it. I mean, I'm not just getting interested in it because I think it's completely fine. Of course, there's been something bothering me with this whole setting, and that's why I wanted to write the book. But doing the combination, I think, has been a difficult thing. And of course, that's one of the things that I'm very sort of interested in hearing how that went in the end, because there are in a way chapters that I wanted to at least try to write more from the descriptive angle, such as the first chapters, which sort of describe who the legal advisors are and what they do. But then I noticed when it comes to the question of confidentiality, that chapter turned really difficult to write as a sort of descriptive exercise, because I felt there is something wrong there that doesn't really work. And I think the sort of critical angle grows then towards the end of the book. And at some point I then gave up with the attempt, that I sort of thought, well, this is my book and maybe my own voice can come through. But I hope it doesn't come through too much so as to destroy the descriptive effect, which I hope to be there. And of course, then the combination, I mean, that there are books written in this area by sociologists and sort of legal historians. And I think I find them very interesting, but in a way, I mean, reading them, you do notice that they're not written by internal people, you know, that there's one dimension missing, that, for example, they're not evaluating the credibility of legal advice given in a certain context, which obviously an internal person can do, that combine also the actual legal work that these people are doing with the descriptions. And I thought maybe I have an edge there, that I can do both. But sort of methodologically, I felt it was a bit unbeaten ground, that it was difficult to find models to follow. So that was, I mean, that's also part of the reason as to why it took so long to finish the book. It was really difficult to find the way that to do it. The feminist thing, well, when I must tell the story with the cover, it was just that Cambridge University Press, I've actually got two books. So this is the first one of the books that concern legal advices. There will be another one, which is an edited volume, and actually addresses several of the questions that Elise was raising of lawyers working in different contexts. So that's an edited volume that goes beyond these three institutions. I've edited it with Emilia Korkeaho, and we're just heading the proof stage. And when I was looking for the cover picture, Cambridge University Press gives you access to a sort of database. I started browsing that database with keywords such as lawyer, treaties, negotiations, court. And the only thing that I don't think I got a single picture of a woman anywhere. They're all dark pictures of men in black robes, and I mean meeting rooms and very sort of dodgy settings. And I was thinking, this doesn't really illustrate my picture of the work. Maybe we should also think a little bit about how we see these legal advisors, because many of the people I've met are certainly not sort of really old men in dark capes, but they come in various different forms, and they're certainly both men and women, and young and old and all kinds. So in that sense, I was thinking, why should I not make my legal advisor a woman instead? Because certainly there are many of them around, and I don't feel that this is a setting that would be particularly problematic from a gender perspective. But why sort of not make my legal advisor a woman just as well as it could be a man? So that's basically my thinking behind the picture. It's a historical picture in any case, in the Finnish context, but also illustrates the broader point.
We have a question from Lawrence Ankersmith in the chat. He's saying that he got from your comments, Päivi, that you consider the relationship between the Commission Legal Service and the Court of Justice to be mainly a positive thing. And he's asking, would you not also think that this relationship could have a negative aspect from the perspective of separation of powers and the independence of the Court of Justice?
A good question, and I hope I didn't actually take a sort of very clear position on that, because in my eyes it actually, let's say, to say the least, actually popped up at a question that we should know much more about. I mean, an example of documents that I've made requests to, just for the purposes of this request, they concern a lot of internal documents from the Commission that regulate the working of the Commission Legal Service. These were documents I did not know that existed, but they were mentioned by a few people in the interviews, and then I thought, I'm just going to try and see if I get them. I thought I would never get them, but I made formal requests, and in the end I actually got them. And among them, for example, was a sort of soft law guide on the ethical rules for the members of the Commission Legal Service. And much of that, for example, concerned the relationship between Commission lawyers and court lawyers, and how close they can be, and if they can appear in a court cafeteria and appear as friends. And I started asking questions about that. And of course, it then appeared that that a lot of Commission lawyers have worked in the court in the past, and there's a lot of ping pong between, especially between these two institutions. So they know each other tremendously well. And that would be the normal thing for a Commission lawyer to do, would be to meet friends when going to the court. And this was it was a specific point made in this guide that don't do it if you're working on a court case. It looks very bad. But of course, it doesn't affect the relationship as such, that you're not entitled to have lunch when in Luxembourg. So I think that is actually an interesting point for someone to do research on. The court itself, I find difficult to do research on. I've never been particularly interested in the court myself, I shouldn't say, but that's the thing. I've always been more interested in the political institutions. But certainly, I mean, doing more research on the court would be important. However, when I've tried that, and when I've made interviews with people working in the court, I've found that they're very hesitant to say anything about their work. And many of the people that I've interviewed who'd worked in the court in the past said they're happy to tell me about their work in a political institution, but they cannot talk about their work in the court. So in that sense, it's going to be a difficult institution to do research on. That's my experience. I also did some interviews in the European Central Bank that I left outside this book. I've done some in the agencies as well. Maybe that will flow into something later, but I thought that the scope of this particular book was broad enough with just these three.
We have a question from Christina.
Yes, if I may, Päivi, I would like to push a bit more on this confidentiality issue, because I mean, in chapter 4, you discuss the as I said, the power grasp through selective disclosure, the argument of legal certainty and whether it's undermined if we systematically disclose legal opinions, the question of whether it could undermine the independence of the legal service. But I would like to think a bit more also what that would mean to the relevance of legal arguments in that discussion, because I think if we see things more through the lens of the different legal services, so let's assume we had systematic disclosures of legal opinions of the different institutions. To what extent don't you think this would also affect what you said about the relationship between the different legal services, of course? To what extent would that also affect that legal arguments would be put more, maybe, I mean, clearly Jonathan was speaking of a religion already, so the question is whether that's desirable is maybe a different question, but would put legal arguments more front and center in a sense that the law would become more subject to that political struggles of every day, which could also be a good thing or a bad thing. But I mean, you speak, for example, in your chapter of the need to justification of choices. And in that sense, I think you clearly also see the positive side of it. But yeah, because I'm very interested in really the relevance of the law in the political day-to-day struggle. And that is something I think that you can very much relate the question of confidentiality to.
Well, yes. I mean, this obviously, when I started working on the book, I thought, well, confidentiality doesn't really come into this, that I may have an addiction to access to document legislation and the law, but it's not a part of this book. It's a separate thing. And then as I started writing it, I actually noticed that, well, it really is at the core of what this book is about, also because this is a piece of jurisprudence, and also, I mean, all these requests that haven't been appealed, they tell us so much about what the legal services think about themselves and their work and the relevance of that work, that I cannot possibly leave it out of the book. You know, that's my best source of explaining how they see their own mission in Europe. And but then, I mean, solving this confidentiality, I mean, I think it needs a little bit of sort of putting into pieces, because I mean, you mentioned first the legal services relationship and the relevance of confidentiality for that. And my feeling is that the legal services know what the other legal services think. So whether sort of there is public access is a completely different thing. I mean, legal services have contacts all the time. For example, the Council Legal Service knows what the Commission Legal Service thinks, and vice versa. And usually they know that already before a proposal comes out, if that proposal is of any importance. So public access doesn't really play in there. And then
I didn't mean that. I meant more that if the controversial positions were brought to light, that you have much less easily agreement behind the scenes. That's much more what I meant.
And of course, hiding behind scenes I don't like. Hiding behind legal arguments, I think, is a bit of a problem. And then, I mean, of course, another thing that we have to understand is that, I mean, in particular, the Council Legal Services opinions are highly influential at the stage of when negotiations are being concluded. The Commission is more relevant at the stage where something is being designed, and it gears the proposals in what it sees as a legally solid direction. But the Council comes in then at the point when solutions are being sort of sought. And of course, the member states have them. And that, in a way, I think has always, for me, been a very odd argument, that it would impact negotiations, because obviously member states have them. the instances that don't have them are national parliaments. And that actually is where some of my criticism goes. And I think that is a part of the democracy problem, in the sense that these legal service opinions are often used by governments against their own national parliaments to explain why certain things have to be done. And I think that is problematic for the EU as a sort of democratic construction, that it sort of, if there is an effect, that plays governments against their own parliaments, because that's the very significant democratic anchor that we have in that structure. And then, of course, another dimension which I think is now highlighted in newer case law. I mean, there's the ruling by the General Court relating to rule of law questions brought by Laurent P, which was just decided by the court some time ago, has been appealed by the Council. And the same dimension comes up in a request that I've made myself, namely the dimension that there should not be academic debate about legal questions while negotiations are ongoing. That access by academics to how the legal services analyze proposals is a problem because it creates, and I quote, external pressure on the institution. And the same thing being said about NGOs. And that, again, is an argument that I have a very hard time living with, because isn't that the purpose of democratic debate, that it may actually influence outcomes? Isn't that the role of academics, that we should be there to scrutinize also legal solutions? And sort of being characterized as external pressure, I think, is a dangerous argument to be used in democratic society. So I'm also thinking when talking about confidentiality and public access, I think we also need to think about access by whom, because usually those who need those opinions for purposes of power have them already. It's the sort of outer sphere that might need empowerment that has limited access. And if that's the case, then I think it's a problem.